Let me go over the regulations that are likely to be finalized by the USCIS. These are interim final regulations affecting the H-1B process. Beginning with just the draft regulations, I have reviewed the 150 pages of their proposed changes, and some of them are quite alarming. It's basically, if you were to ask me what is the shortest summary of what the government is doing, what they are doing is they are reverting back to the Neufeld Memorandum 2010 and making it even tighter. So for instance, now if you are placing employees at third-party sites, you will only get 1-year approvals at one time. Let's go over the regulations as they're being drafted so I can make comments. So if you look at this, these are the changes in a summary: employer-employee relationship, specialty occupation, etc., etc. But let's look at the details. So we begin with, first of all, they do say that we are not going to require itineraries for H-1Bs. That's not a big whoop, not a big deal. Nothing here that excites us. That's neither relaxed nor restrictive, about the same as it used to be. So they are just putting it in the regulations that itineraries for multiple site locations will not be required. They are making it clear that they'll be conducting site inspections, and they can do it before they approve the papers, before they approve the H-1Bs. They can go to your headquarters, satellite locations where the employee will work, including third-party work sites. That's basically what they do even now. And then this is the part that's bothersome: employer-employee relationship. They are reverting back to the Neufeld Memorandum and making it even tighter, because in the Neufeld Memorandum, it was the right to control that determined employer-employee relationship. USCIS has removed that, and they have said we will be reverting to the common law definition of employer-employee relationship, where a bunch of factors have to be weighed, with no one factor being determinative. Now, USCIS is not known for its consistency. Because this leaves so much to their discretion, it should make everyone nervous. They have also made it tighter for people who own stock in their own companies to do H-1Bs. So it'll be a little bit more difficult. But let's look at those cases where there is no ownership interest first. So they'll be looking at all these factors, whether the petitioner, which is the employer, the one who does the H-1B, supervises the beneficiary. How does it supervise? Of course, right to control is important, but actual control is more important, it looks like. Tools or instrumentalities, who supplies those, whether it is the end client or the employer. Do they have the ability to hire, pay, ability to fire? Who evaluates the work product? Does the employer claim them as an employee for tax purposes? Do they provide benefits? Does the employee use proprietary information of the petitioner? So unless you are a product company, your employees would not be using your proprietary information. Is the end product directly related to the petitioner's line of business? That has been always a little troublesome in the field of consulting, because if I'm a consultant, I am producing consulting for my client. So that's directly linked to my line of business. That's an argument, but that's something the government has been trying to cut at. The entire regulation seems to be focused in cutting down the third-party site placements, staffing companies, consulting companies' work. And the court noted in series of decisions that it appears that the government is targeting high-tech business, and especially businesses where employees are being placed at third-party sites. What is bothersome about this regulation is it is based upon, if you look at the justification, if you read through the justification, it is based upon a bunch of anecdotes and third-party studies conducted by private citizens, in my view, who have their own agendas. There are no bipartisan discussions, there are no bipartisan studies. And they say, we are doing this, we are promulgating these regulations, and that's where I think they're going to get beaten up in court, because they are proposing to promulgate regulations to address rise in unemployment in the technology industry. But wait a minute. What do you mean by technology industry? Technology industry has so many subspecializations. So you cannot think of a Microsoft Access developer as the same as a Hadoop administrator or developer. You cannot think of somebody who is doing, for instance, simple quality assurance, and you cannot compare them with a chief architect, system architect. It's a totally different job profile. So these studies, I think, are open to challenge, and I think the government will lose on two reasons. Once they get sued, they will lose because of two reasons. One, as the Ninth Circuit has noted, one of the federal courts in Ninth Circuit has noted in the National Manufacturers Association decision that came out on October 1st, it was a preliminary injunction barring the government from applying the ban, H-1B L1 ban, to members of the Chamber of Commerce and the National Manufacturers Association. The court noted that President does not have unlimited power when it comes to trying to regulate domestic policy under the pretense of foreign relations. So just because you say immigration, you don't get to do whatever you want. That's their number one problem. They are claiming that COVID-19 is making it necessary to take these actions. Number two, their second weakness is they don't have enough studies to really back up the data they propose they do have. I would be surprised if they are able to pass muster. So if these cases would be challenged, I think these two, along with the third one, which is an abbreviated notice and comment period, basically they're just pushing the regulation through. To me, it's an election stunt, but then I'm a huge anti-Trump Democratic platform supporter, so in all fairness, I may be prejudiced. I think this is just an election stunt. Even the government knows they're going to get thrown out in court. At least that's what it looks like to me. Of course, courts are unpredictable, you never know. Then, does the employer have the ability to control the matter and means? Then when you come to the ownership interest, they are looking for making sure that the employer-employee relationship is actually there. Somebody can hire or fire the stockholder who's also an employee, an H-1B holder. Is their work supervised? Do they report to someone higher in the entity? And do they influence the petitioning entity? Are there written agreements and contracts? Do they share in the profits, losses, etc.? So these are some of the things they'll be looking at, making it more difficult for self-owned companies to petition for their key employees who are also their stockholders. Then this is another alarming development. They are trying to create a new definition for specialty occupation. They have gone back and tightened up what was time and again challenged in courts and they lost in the courts. What they've done is they have said specialty occupation is an occupation that requires, first of all, they talk about a bachelor's degree, etc. That's the same as it was before. The degree must be directly related to what you do. That is also the same as it was before. But I'll tell you a little bit more further down. A general degree is not sufficient. For example, courts have said, let me rephrase that. Government has said that business administration is not a a specialization. Some courts have disagreed, and I think this is highly questionable. Even an MBA is not a professional degree. I don't know if this is, courts will buy that long enough, because to hold that a specialization in business is not a specialization, I think it begs a challenge to your common sense. So I don't know. I don't know how far this will go. But they do say that you can have a range of degrees as long as they are closely related. Now, what did they change? I'm trying to remember. One of the things was, in specialty occupation, there were in the regulations words like degrees are usually required, commonly required. They removed that. So what they are trying to do is raise the level of proof. And that's another challenge I can make to those regulations, because the overarching requirement under immigration law for most things is proof to a certain level of certainty, and that level is called preponderance of the evidence. Technically, that's called preponderance of the evidence. In common person's term, it simply means I have to prove my case only by about 51% certainty. I don't have to make it 60% certain, 70%, or as in criminal law, almost 100% certain, which is beyond reasonable doubt. So preponderance of the evidence standard, which obtains in immigration law, seems to be strained by this removal of usual common requirements. And I'm not sure how far that is going to go in courts when we start challenging it. That is the major new introduction in the specialty occupation definition. Then they're trying to tighten up third-party work sites placements. They've defined work site, that was the same as before. And then they talk about the criteria. Remember those 4 criteria they used to have. The first criterion is that you have to prove one of the 4 to qualify as a specialty occupation, and I think the 4th one will be the one that's most likely to be used in most cases. First criterion is that you have to prove that across the board this degree is required in this occupation. So we are talking about an industry standard here. Second is, this is the same as we had before. It's in parallel positions at similar organizations. This is required. Third, and this is where the small businesses and the startup businesses get challenged, that the employer has an established practice of requiring a bachelor's degree for this job. Again, you have to meet only one of the 4. And the 4th one, as I said, is the one that is most likely to succeed in many cases, that the duties of the job are specialized and complex. They require a degree. Then again, going back to what they have been requiring anyway, they want proof that we actually have work. So contracts, work orders, things like that. And we also have to prove employer-employee relationship through work orders, contracts, and or client letters. So we are back to the same space we were. If they give us an H-1B, I said that they are going to give third-party site placements H-1Bs only for 1 year at a time. If they give it for shorter duration in that situation or any other situation, they'll give a brief explanation, which I think is garbage. They'll just develop some kind of a template language that has very little meaning. And as I said earlier, when we got started, that the regulations will become effective 60 days after the date of publication. So far, they've not been published. I'll keep you folks informed. In the meantime, the Department of Labor has also published regulations, and I'll make a video on that, put that out there. The Department of Labor regulations raise the wages, and for most of our clients, that's not an issue because they're already paying at level 2 or level 3. So they're simply raising the wages by a certain percentage. I'll give you more information on that, but this was important. I wanted to cover this. Good luck, folks. Hang in there. We'll see how far this goes. And remember, if Republicans lose, everything changes. because we can expect a much more balanced perspective. We can expect, I hope, I would strongly encourage a bipartisan study for a comprehensive legal immigration reform. What is happening now is that we are making policy based upon emotions and impressions rather than the interest of the United States. It's just crazy how this administration has made policy. Hopefully that will change soon.